don't forget, I can use the Insurrection Act. 50% of the presidents almost have used that. And that's unquestioned power. I choose not to. I'd rather do this. But I'm met constantly by fake politicians that think that, it's not like a part of the radical left movement to have safety. These cities have to be safe.
This is Democracy Watch. Mark, that was Donald Trump speaking with Maria Bartiromo on Fox, talking about the Insurrection Act, which you and I have spoken about at length, saying that almost all presidents have used it and that it's an unquestioned power. That is the exact words that he used. So first and foremost, can you speak on this idea that being able to invoke the Insurrection Act is an unquestioned power for a president to wield?
Okay, so a few things. First is, it is not true. Almost every president has used it. I don't know where the hell he makes these statistics up. Second, a statistic that everybody should be paying attention to. This is, Brian, in my 300th video. So I hope you like this series. I hope you have watched all 300 or at least most of them. But most importantly, I hope that you will subscribe to this channel, because that is the way you will make sure you get the 301st, 302nd, and 303rd, as there will inevitably be in the Donald Trump era. So go ahead and hit the subscribe button. If you're already subscribed, hit the bell to make sure you are updated whenever new videos are posted. Okay, so here is the thing. The Insurrection Act is the closest thing we have in our legal system to presidential martial law. Now, it's not martial law like we expect in a third world country. It's not martial law like in Russia. But what the Insurrection Act does is it effectively gives the president the ability to make a determination that he can use the military, not just National Guard, but active military, and that he can use it in law enforcement functions. So right now, he is mostly confined to using the National Guard, and he is completely confined that the National Guard cannot be used to perform law enforcement responsibilities. But what the Insurrection Act allows him to invoke it, and then that door opens. And now, in terms of his authority here, look, the law has historically been that the president is given great deference in deciding whether or not there is a rebellion, whether or not there is an insurrection, whether or not, there is a sufficient threat necessary for the president to take these dramatic steps. But that has always been against the backdrop of a president who has seen the Insurrection Act as a last step, not a first step, and has really used it where the states themselves are either in a state of rebellion, or in the case of some historical incidents where the states were near full-scale rebellion. But here you have governors in California, governors in Illinois, governors in Oregon, in wherever he's thinking about this, that are actually more than capable of keeping law and order, and in fact are doing so.
Yeah. And just as a quick aside, before we go into the next question here, Mark, you've been doing excellent coverage on everything related to the Insurrection Act and all of these illegal troop deployments. Highly recommend for everybody who's watching, if you're not yet signed up for Democracy Docket, which is the news outlet Mark founded to focus on everything voting and elections, please do yourself a favor and sign up. It's not only a great resource, but it's a great way to support the invaluable work that Mark and his team are doing as well. So I'll put that link right here on the screen and also in the post description. Mark, in terms of this idea of the courts giving Trump deference, let's jump ahead and say Trump does invoke the Insurrection Act, and that's challenged in court, and a judge has to decide whether he has the power to do so. Will that judge take into account the fact that Trump has been given deference in other instances where it's borne itself out that he didn't deserve that deference? He came forward and said that there was some pretext, some legitimate justification to deploy the troops in Los Angeles. That was swatted down. He did the same thing in Portland. That was swatted down, by the way, by a judge who he appointed, who said that his justification was untethered to the facts. Did the same thing in Chicago. That was swatted down. And so I understand that the judges have to saw the legal wood in front of them and take every case in kind of a vacuum. But to what extent is the fact that Trump is operating under bad faith and trying to basically usurp all of this authority that he doesn't have in other cases, to what extent does that impact a judge's decision when looking at this specific idea?
So look, we don't know, right? I mean, the Insurrection Act has been rarely invoked and even more rarely challenged in court. And so there are some guideposts to go by, but not a huge number. And the instances you're talking about have not been under the Insurrection Act. They've been under other claims of presidential power. But your point is well taken, which is that even under those statutes, which are less draconian, courts have found that Donald Trump has failed to clear this bar. But the question is whether or not the courts, and in particular the appellate courts and the U.S. Supreme Court, will just look at the plain text of the Insurrection Act, say this is a presidential power, and we trust our presidents to ensure that they are, invoking it appropriately. That is the position of the Trump administration already before we get to the Insurrection Act, that essentially these are unreviewable decisions, that the president gets to make this judgment and courts can't second guess it. That is a recipe for dictatorship. We just had No Kings protests. And, the recipe for a king is saying that he can deploy the U.S. military domestically without really any constraints and without any review about whether or not it is necessary. I'm sure like you, Brian, I watched as police department after police department announced that there were was no reported reports of violence at the No Kings rallies and no arrests. And you are left thinking, only Donald Trump would say a bunch of, people dressed up in dancing frog costumes is enough to claim that there is an insurrection. But the question is, what if he does that? What if he says that, people dressed up as cartoon characters? Or Mike Johnson saying that a naked bike ride in Portland, Oregon is, signs of the apocalypse. Will the courts say enough is enough? We're not going to participate in the undermining of American democracy because Donald Trump wants to cosplay dictator? Or will they say, yep, we're all for it, and then it's not cosplaying. Then he actually becomes the equivalent of a king or a dictator.
Right. Well, on this idea that Trump is going to go into court or move forward with this whole process with this idea, as he said here, that it's an unquestioned power, that he has this unreviewable power, isn't the whole system of government that we have so that one branch of government doesn't have an unreviewable power? I mean, is that not the whole point of the legislative branch and the judicial branch acting as a check on the executive branch? Where does this idea of unreviewable power for the president even come from if it's wholly antithetical to the system of government that we have in place?
Look, I'm not defending Donald Trump at all, but I will say that his position, I think, would be, if he was sensible, which he's not, and if he was coherent, which he's not, and if he wasn't a fool, which he is, but his position would be that Congress could repeal the Insurrection Act any time. So when you mention Congress is a check. But Congress is choosing not to check him. Now, that is sort of self-defeating in this instance because Congress is as useful as a dead log in the forest, right? I mean, Mike Johnson and John Thune are not going to do anything to limit Donald Trump, and so that is just another way of saying that Donald Trump gets to be a dictator because he has completely taken over the Republican Party, and the Republican Party controls Congress. So we can't allow the Constitution to essentially become a suicide pact into which democracy dies because the separation of powers is broken down, and we need the courts to play their role. And their role has been, since the founding of the Republic, to interpret law, but also apply constitutional limitations to those laws. And in this instance, a broad application of the Insurrection Act without any judicial review about whether or not the facts underlying it are true would be judicial abdication, and that would be a catastrophe for democracy.
If you were arguing this case in front of the Supreme Court, where it may inevitably go if Trump does try to invoke this thing, and you have a few different options in terms of how to fight back against this. You can push back against the idea that Congress is not serving as a check. You can push back against this idea that Trump has a legal justification to do it, even though we know full well that he moves forward with no bases to be able to invoke anything, whether it's these troop deployments or the Insurrection Act. He's just going to lie and say that things are happening that don't exist because he saw it one time on Fox News 5 years ago. How would you argue this thing, knowing that you want to put your best foot forward in terms of pushing back against these instances of overreach at the hands of Trump?
Yeah, look, I would fundamentally make a very conservative argument. So people may remember that a year ago, the Supreme Court overturned a doctrine called Chevron deference. And what that doctrine said is that we give the executive branch the ability to interpret statutes, and where terms are vague, we give them great deference in the interpretation of those statutes. And the Supreme Court overturned that. This had been a doctrine for decades, but they overturned it. And what they said is that courts are experts in interpreting statutes, not the executive branch. And so the argument I would make to the Supreme Court is quite clear, which is that courts are expert in making a determination about what a statute means. And that means determining whether or not the facts presented meet the definition of insurrection, or meet the definition of rebellion, or meet the definition of threat, whatever the operative term is. I think that we need to hold the Supreme Court to what it has said, which is that the courts are the experts in interpreting statutes. And so I think that I would lead with that. The other argument I would make is an institutional argument, which I think might have attraction for the Chief Justice and perhaps Justice Kavanaugh, which is that, the courts are being asked to essentially render themselves out of the system of checks and balances. Yeah. So it's all well and good to say Congress isn't doing its job, but fundamentally what Donald Trump is trying to do is to write out of our constitutional arrangement the courts. And if I were pitching this case to the Supreme Court we have now, I would lean into that. So those would be the two arguments I would make, both of which, like I said, are actually conservative arguments that have historically been advanced by conservatives. And then finally, I would make an originalist argument, which is that the one thing that the founders worried about was a king. The one thing that the founders worried about was a president that would be too powerful and would aggregate power. And therefore, against those first two arguments I laid out, I would put an originalist underlay to say, and that therefore the originalist understanding of the Constitution and of a law passed in 1807, which is when the Insurrection Act was passed, does not counsel in favor of unbridled presidential power.
I was trying not to laugh while you were talking about Chevron, because it was, I found it so, first of all, it's the smartest defense that I could have, that I could imagine to put forward. And it's a testament to how good you are at what you do. And if I'm not mistaken, you've argued 4 times in front of the Supreme Court and won 4 times in front of the Supreme Court. Is that correct?
Correct. I'm 4-0, and I've got a big argument coming up this December.
All right. So, it's just, I was trying not to laugh, because it's funny to try and put forward a decision that this Supreme Court decided to hand down apropos of nothing. This was their own settled precedent, and then to put their own argument in front of them, I thought was very impressive. And so I'm wondering, in these instances where conservative doctrines are put in front of this Supreme Court, have there been instances where the court was expected to rule one way, but then was presented with an argument that, in theory would align with their conservative ideology, and where they've actually gone the other way and been persuaded by this argument? And this kind of, the reason I ask this is because I'm very interested in the broader question of, can these conservative justices actually be persuaded? I think from a layman's perspective, it just seems like every conservative, party that goes in front of this court, it's a 6-3 ruling in favor of the conservatives, whatever will help Donald Trump, even if it's completely antithetical to conservative ideology, even if it's completely antithetical to previous rulings or stare decisis, past precedent. And so I'm just curious here if there has been effectiveness in terms of putting conservative doctrine, conservative ideology in front of these justices that may not help Trump in this moment, but still adheres to this general idea of conservatism.
Yeah, so it's a really good question. It's being hotly debated right now because we're facing a series of cases going before the Supreme Court. I will say, as someone who's argued, as you mentioned, several cases before the Supreme Court and won them, and has argued hundreds of cases before courts of appeals and state Supreme Courts, and even more than that when you get down to the trial court level. I think one of the reasons why I have had some success, and I think this is true of any lawyer who has had success before a diversity of judges, is that you need to meet the judges where they are. It's all well and good that you've got a theory of the Constitution, or you've got a theory of the law, or that there are precedent that you like, but you really need to understand where they're coming from. And so if you're arguing before this Supreme Court, you don't want to lead with a bunch of cases written by liberal justices,
Right.
even if those are majority opinions, even if those are precedent. You want to try to meet this conservative the court where they are, and that's why I immediately go to Loper Bright, which is the case that overdid Chevron deference. It's the reason why I go to originalism, and it's the reason why I go to separation of powers. To answer your question directly, look, I would argue that the cases, that at least some of the cases I won in the Supreme Court, that was, I was advocating a right of center doctrinal position involving racial gerrymandering, which we could get into at another time, and the independent state legislature theory case, which everyone thought we were going to lose. Everyone thought we were going to lose. I didn't argue that case in the Supreme Court, but my law firm represented the lead plaintiff there, Becky Harper. And, this was the question of whether or not state courts could apply their state constitutions to invalidate voting rules passed by state legislatures. And that very much case, which everyone expected we were going to lose, we wound up winning because we really did adopt a sort of an originalist and a fundamentally conservative frame around it, and it wound up, at least for the time being, deferring, being a victory. Now, part of the problem, Brian, in these cases is that sometimes you're just deferring out for another case for the conservatives and the Republicans to regroup and find another way to present it.
Yeah.
We're seeing that also play out in the Supreme Court.
Well, we'll leave it there. One more note before we end this episode, and that is that Mark mentioned that this is the 300th episode of Democracy Watch. I just want to say on behalf of me and the people who watch this series regularly or who just pop in, a huge thank you to you for not only bringing this wealth of knowledge and experience to us, multiple times a week in these episodes, but also for the work that you're doing right now. I've been exceedingly focused on who are the fighters in this moment, and they're few and far in between, but you are consistently always at the top of that list. So not just thank you for the work that you're doing in this series and for giving me and all of us a little bit of time every day to learn about this stuff and to hear your explanation for this stuff, but also for the work that you're doing in the courts, on the front lines, where it matters most. For those who are watching this series right now, a small step that everybody can take to support Mark and his team is to sign up for Democracy Docket. If you're not yet signed up, it is a resource that I use on a daily basis, and it has really begun to stand out, not just among its peers in legacy media, but just among all media, in terms of covering this stuff accurately, truthfully, but also covering stuff that the rest of the media doesn't cover, and certainly does not fall into the trap of both sidesism or any of the other diseases that have plagued our broader media ecosystem. So again, if you're not yet signed up for Democracy Docket, I'm going to put that link right here on the screen and also in the post description of this video. And Mark, thank you so much for 300 episodes, and looking forward to the next 300.
Yeah, and Brian, thank you. Thanks for giving me the opportunity to be a part of this, to be a part of your channel, and to help spread the word of democracy. You have a lot of loyal followers. You have really been an unbelievable help to growing the Democracy Docket audience, both its newsletters, its website, and its YouTube channel. So I want to thank you on behalf of all of them. And also, I want to take this opportunity to thank you for everything you do in bringing along other creators. There are a lot of really selfish people out there in the world, and competitive people out there in the world. And Brian is one of the few people who brings onto his channel, not just to inform you, the viewers, but also to help the creators grow their own following. He believes in a more is more approach, and that is refreshingly rare, unfortunately rare, but refreshing to have. Brian has been involved in Chorus, which has been an unbelievably important incubator project for young creators, for new creators to build their audiences. But he's also been incredibly helpful for people like me who are just trying to help get their word out and build their own media ecosystem. So really, I hope everyone subscribes to this channel. I hope you hit that bell to make sure you stay up to date, and I hope you support Brian in every way you can.
Well, I appreciate that. I'll put the link to my channel and to Democracy Docket right here on the screen. So again, if you're not yet subscribed, please go ahead and subscribe. I'm Brian Tyler Cohen.
I'm Mark Elias.
This is Democracy Watch.